The management of Articles 307, 308, and 309 of the Criminal Procedure Code of the Russian Federation finds Alexei Viktorovich Kopachevsky guilty of committing the crimes provided for in Part 2 of Article 213, Part 2 of Article 3, Part 1 of Article 318 of the Criminal Code of the Russian Federation, to whom the punishment for the crime provided for in Part 2 of Article 213 of the Criminal Code of the Russian Federation in the form of imprisonment for a term of 5 years for the crime provided for in Part 2 of Article 3, Part 1 of Article 318 of the Criminal Code of the Russian Federation, imprisonment for a term of 4 years and 6 months on the basis of Part 3 of Article 9 of the Criminal Code for a combination of crimes. By way of a partial statement of the appointed punishments, Alexei Viktorovich Gorbachevsky was finally sentenced to imprisonment for a term of 6 years to be served in a general regime penal colony until the verdict comes into legal force in relation to the service measure of restraint to leave previously in custody the term of serving the sentence. To calculate the sentence's enforcement date, credit the convicted person's sentence served during the period of his detention in custody in this criminal case from the moment of his actual detention from June 23, 2022 until the date the sentence comes into force. This means that Kirill Vladimirovich Gunin is found guilty of committing the crimes provided for in Part 2 of Article 213, Part 2 of Article 35, Part 1 of Article 318 of the Criminal Code of the Russian Federation, and that he is sentenced to imprisonment for a term of 5 years for the crime provided for in Part 2 of Article 213, and to imprisonment for a term of 4 years and 6 months for the crime provided for in Part 2 of Article 35, Part 1 of Article 318, based on Part 3 of Article 9, based on the aggregate of the crime. By partial addition of sentences, Kirill Vladimirovich Gunin is finally sentenced to imprisonment for a term of 6 years with serving the sentence in a strict regime penal colony. The entry into force of the sentence against the convicted person is subject to the following preventive measure. Before the entry into force of the sentence, the guard shall set the term of serving the sentence in the number and the entry into force of the sentence for the honor of the convicted Bunin, the term of serving the sentence during his detention in custody in this case from the moment of his actual detention from June 23, 2022. The entry into force of the sentence on the basis of paragraph B of Part 3 of Article 72 of the Criminal Code. The time of detention was taken from the moment of actual detention from June 23, 1922 until the date of entry into force of the sentence, for the term of imprisonment for the calculation of 1 day for 1.5 days of serving the sentence in a general regime penal colony, and to recognize Potovari Vladimirovich as having committed the crimes provided for in Part 2 of Article 213, Part 2 of Article 300, Part 3 of Article 318 of the Criminal Code of the Russian Federation and to sentence him for the crime provided for in Part 2 of Article 213 of the Criminal Code in the form of imprisonment for a term of 5 years, for the crime provided for in Part 2 of Article 35, Part 1 of Article 318 in the form of imprisonment for a term of 4 years and 6 months on the basis of Article A, Part 3 of Article D, according to the Sovok of crimes by partial addition of the imposed sentences, to finally impose a sentence of imprisonment for a term of 6 years to be served in a general regime penal colony. The sentences are legally binding regarding the imposed preventive measures, leaving the sentence term unchanged. The sentence entry into force for the convicted person is calculated based on the sentence's term of service during his detention in this case, from the moment of his actual arrest on June 23, 2022, the date of entry into force of the sentence based on paragraph D of Part 3, Note 1, Article 72 of the Criminal Code. The time of detention from the moment of his actual arrest from June 23, 2022, the date of entry into force of the sentence, is calculated based on 1 day for 1.5 days served in a general regime penal colony. The final sentence is 6 years imprisonment. The defense has not yet received the text of the sentence. Only the final part has been released to the convoy. After reviewing the full text, it will be clear how the court reasoned its decision. Overall, the guys are in a positive mood and plan to appeal these sentences. As far as I know, each of them plans to appeal the verdict. At this point, with a 1.5-day deduction, they've already served 5 years and 45 days. Accordingly, if the sentence is upheld, the 6 years, with a 1.5-day deduction, will expire in July of next year. I'm going through the trial behind closed doors. Moreover, the reason for closing the trial was concerns about some kind of pressure on witnesses or victims, which had been voiced in the previous trial, 2 years ago, even 3 years ago. Unfortunately, no new information was presented to the court. Our objections were ignored. Despite this, not a single witness or victim appeared in court throughout the entire trial. We requested that the trial be reopened after the prosecution's evidence is presented, that is, after the defense's evidence has been presented. Unfortunately, the court refused, even though we pointed out that our witnesses and experts were not under threat, and we could hold the hearing in public. Unfortunately, we were also denied this request, and the hearing was only open during the reading of the verdict, which was in full view. Regarding the charges themselves, the charges brought against us, several versions of the charges were presented to the guys, including the final version of the report, which was presented during the trial 2 hearings later. The new text of the charges was handed to them. Specific blows are described there, but they completely contradict the video that the defense submitted to the case file. That is, what we see on the video, what the experts assess and describe in the videos they reviewed, contradicts the charges set out in the written document. Therefore, in this regard, too, in our opinion, the charges are unproven and directly contradict the objective evidence we were already able to establish and present to the court. No expert examination was conducted. In the legal sense, no forensic examination was conducted. There were expert opinions submitted by the defense. These are procedurally different matters, but essentially, it's the same expert with the same level of education who evaluates the video recording and the statements, movements, and motivation contained therein. Therefore, in the legal sense, no expert examination was conducted, although we petitioned for one based on our expert opinion. Again, all our petitions were rejected, so it's impossible to say there was any objectivity in this case, well, according to the defense. The verdict stated that Kirill Bunin would be sentenced to 6 years in a maximum security penal colony. I think this is either an error, an omission by the court, or an objective judicial error, which will be appealed, since in this case, a maximum security penal colony doesn't apply to him, and, the sentence announced for the other participants was a general security penal colony. It's either an omission or an objective judicial error, which will be cited. In any case, if the verdict, the paper verdict, states a general regime sentence, then we'll have a difference between the announced verdict and the paper verdict we receive. If this error is reflected and the paper verdict states a strict regime sentence, we'll appeal it. Naturally, it's still one of the arguments in the appeal. Yeah,